I want to talk about copyright protection for design professionals. Architects, engineers, and other designers are entitled to a copyright for the works that they create. And when I say create, that means putting an idea down on paper. It's the expression of the idea that's protected, not the idea itself. So if I have an idea for a round building, that idea has no protection under the Copyright Act. But the moment I draw that idea, the drawing that embodies that expression, the sketch, the construction document, whatever it might be, if it's down in a tangible medium, whether it's on paper or in a computer file, that's protected by the Copyright Act. So ideas are not protected, but once you draw up that idea, that is protected under the Copyright Act. Now there's something called registration. So you don't have to do anything to be protected, but if you want to enforce your copyright, let's say somebody infringes on your drawing and does another project using your architectural or your engineering drawings, then you need to first register your copyright with the Copyright Office before you can go ahead and file a lawsuit against the infringer. It's pretty simple to do, and we actually have a video that shows you how to do that. You go to the Copyright Office website, you can fill the form out online, pay your fee, and then upload your PDF files with all of the relevant drawings. Now, you don't need to have a copyright notice on your drawings, but it is a very good idea to do that. And you can put that in your title block. You have the year that that drawing is created, who the author is, and the word copyright or the C in the circle. Now, the author is the party that created the document, but if it's an architectural firm, a corporation, a partnership, then the author is considered the firm itself, because that the employee that did that drawing, that's considered a work for hire. So the employee of the firm does not have the copyright. The firm itself has the copyright. On the other hand, a lot of people think that an owner that hires an architect, that the owner owns the copyright in that automatically. That's not the case. The author is still the architect unless the architect by contract transfers the copyright to the owner, and that can happen. But generally, it's the firm that creates the drawings, or in the case of an individual architect working under his own name, then it's that individual that has the copyright. The other thing that's important to know when you're talking about construction type of documents as opposed to a book or a recording or something like that, there are two types of copyrights that are available. One is as a technical drawing. So the drawing itself that the architect creates, the technical drawing copyright prevents somebody from taking that drawing, putting it on the Xerox machine, or tracing it and creating a duplicate of that drawing or something very similar. In other words, you can't copy that drawing. But what about the building itself? Years ago, you were able to go to a building, measure it, and build another building off of that without infringing anybody's copyright. However, since 1990, that's changed. There's a second type of copyright that's available to design professionals, and that's an architectural works copyright. And that prevents somebody from actually doing just what I said, measuring the building, creating a new set of drawings, and then making a copy of that. So for any architect or engineer that's doing architectural works, habitable buildings, then you need 2 copyrights for maximum protection. And again, you can do all of this online at the Copyright Office website. Copyrights are very important, and you need to pay close attention. And the time to do that is when you initially enter into a contract with the owner, if you're the architect, or if you're one of the engineers, then your architect engineering contract should cover copyrights and what the parties intended.